Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's episode is What is or Isn't Unfair Competition? An analysis of the FTC's 2022 Section 5 policy statement. In November 2022, the FTC published a policy statement regarding Section 5 of the FTC Act, which regulates unfair methods of competition in or affecting commerce. In this episode of Our Curious Amalgam, we'll explore what the policy statement says, how it does or does not diverge from past Section 5 practice, and the expected impact of the policy statement. Joining me today is my co-host, Jaclyn Phillips. Hey, Jaclyn.
Hi, Christina.
So tell me a little bit more about what we're talking about and who our guest is.
Absolutely. Angela Landry is our guest today, and she is counsel in Freshfields Antitrust, Competition, and Trade Group. Angela's practice involves advising clients on antitrust issues, including merger control, corporate compliance programs, and investigations brought by the FTC and Department of Justice. Before joining Freshfields, Angela was an attorney advisor at the FTC. Angela is particularly well-suited to speak to us today about Section 5, having been at the FTC when it released its 2015 commission statement. So, Angela, I know you have had a particular interest in Section 5 since law school, so we're really excited to welcome you today and get the benefit of your expertise of what we can make of this new statement we all just read.
Thanks. Happy to be here.
So to set the stage, can you give us a brief overview of what Section 5 is and the purpose of the FTC's policy statement?
Sure. So from a 30,000-foot view, Section 5 is the authorizing statute for the FTC. It covers both the FTC's consumer protection and competition missions. The policy statement relates to the competition mission and specifically the language that prohibits unfair methods of competition. So, digging into what unfair methods of competition means, it's well accepted that it prohibits the same kind of conduct that's prohibited under the other antitrust laws, so the Sherman Act and the Clayton Act. It's also well accepted that unfair methods of competition prohibits additional conduct that's not covered by the Sherman and Clayton Acts. The scope of this additional authority, we colloquially within the antitrust bar know it as standalone Section 5. And Congress left it to the FTC using its experience and expertise to use its enforcement efforts to define the contours of standalone Section 5. But that hasn't really been done up to this point. It's been 100 years since the statute was enacted, and we don't really have a great sense of what standalone Section 5 covers. I don't think that it's really debatable that Section 5 theoretically could be very broad. The language is very broad, from a legal standpoint. But the way I look at it, what we've been debating, for these past 100 years about standalone Section 5 is the policy. It's a policy debate at this point. How far should standalone Section 5 go? What are the analytical standards that the FTC should be using to further competition policy now that it has the benefit of, a century's worth of experience with antitrust issues and with the case law under the other statutes?
You mentioned it covers other antitrust laws plus more. What was the congressional impetus for passing Section 5 and sort of why we believe it sort of is broader than the existing antitrust laws?
Yeah, so the purpose of it was to go beyond the other antitrust laws. It was, 1914, not long after the other antitrust laws were enacted, and the Supreme Court had started looking at things under the rule of reason, and Congress was concerned that the rule of reason was going to be too broad and leave it too much to the courts to decide what is a violation of, say, the Sherman Act. And so what they wanted to do was create the FTC, which would be an expert body that would be thinking about, actual competitive issues and give them more authority to decide what actually is, against the law.
So as we sit here today, I think, we want to learn a little bit more about what the FTC as an expert body has said about what unfair competition means. And we mentioned earlier that you were at the FTC when a 2015 commission statement was issued. So what was the FTC's approach in that 2015 guidance, and how, has the FTC approached standalone unfair competition claims since then?
Yeah, so the FTC's approach has been a lot more in line with the analytical approach that's been taken under the other antitrust laws. The statement confirmed that the agency would be looking at consumer welfare as a singular goal, as opposed to including other public interest goals that might be better addressed outside the antitrust laws, or that might conflict with consumer welfare, which could raise issues with enforcement. Meaning, maybe there's a consumer welfare goal, but there's also a goal of ensuring that workers don't get laid off. There could be conflicts there. And the purpose of that, of the commission saying that consumer welfare was the purpose, was to make clear to businesses that that is what the agency is focused on. The commission statement also said that it would evaluate conduct under the rule of reason. So it would be balancing efficiencies and business justifications against the competitive harm that would be expected to come from the conduct that it's investigating.
So is it fair to say that based on the 2015 statement, the FTC was taking an approach that in some ways consumer protection under Section 5 was kind of in line with, the type of conduct that we'd see being challenged under the antitrust laws, or was there a sense that it could be broader?
I think there still is a sense that it could be broader. It's been well accepted that invitations to collude fall within standalone Section 5. Maybe there's a little bit of question about that now that we've seen a Section 2 criminal case that just came out with an invitation to collude. So maybe it is not standalone Section 5. But I think the consensus is that it is supposed to be broader. The agency is supposed to be allowed to look at conduct that doesn't necessarily violate the Sherman Act or the Clayton Act. But what the agency did at the time was really just try to limit overreach and limit its ability, or at least tell the public that it was limiting its investigations to a policy under, I think it was the Obama administration at the time, that the FTC in its competition mission would look at competition through this consumer protection lens, and would not be thinking about other policy issues when doing that. And that was really just intended to provide clarity, because there is, and I think has for 100 years been a concern that the agency will just do whatever it wants, whatever is interesting from a political standpoint.
So turning now to the new statement issued in 2022, how does the policy statement change the FTC's previous approach to Section 5? I think it's fair to say that it takes a more expansive approach than we've seen. So can you tell us how this policy statement does that?
Yeah, it's a completely different approach. The main change is that it hugely expands the scope of the business practices that the FTC says that it intends to use Section 5 to investigate and to prohibit. It explicitly says that it will not use the rule of reason, which is a complete change from the 2015 statement. It also suggests quite a bit of skepticism of business justifications to, justify the legitimacy of certain business practices. It doesn't explicitly address the consumer welfare standard, but in Commissioner Wilson's dissent, she says that she thinks that the majority is repudiating the consumer welfare standard. Chair Khan in her statement also said there's no basis in precedent for applying the consumer welfare standard wholesale to Section 5. And in fact, that the text and history of the statute suggest the opposite, that it should not be limited just to consumer welfare.
Does this expanded approach have any grounds, either cited in the statement or elsewhere in, cases involving Section 5 that is kind of grounding the FTC's analysis of Section 5 in this policy?
Yeah, so the policy statement cites to a lot of legislative history. It cites to a lot of cases. I've been digging into some of these cases that have been cited in the policy statement. Some of them are standalone Section 5 cases. A lot of the basis of, I think, where the new analytical standard comes from is from the legislative history that just said, Congress intended for it to be really broad. And we think that we know what that means. And the case law that's been cited, a lot of it is some of this pre-Chicago school kind of case law that really is what, drove courts to look at the other antitrust laws through the rule of reason and through an economic lens.
So we've been talking about how, conduct broader than the antitrust laws is contemplated by the legislative history, and there's always been some sense of agreement that Section 5 could approach conduct that is broader than what is actionable under the antitrust laws. So the statement lists categories of conduct that it talks about, and the first one it describes as a non-exclusive set of examples of conduct that have been found to violate Section 5, and the policy statement discusses incipient violation of the antitrust laws, even when the conduct is by a party without monopoly or market power. So it seems like, this in particular could reach an expansive range of conduct when you're not, you don't have a monopoly or market power kind of screen or requirement like you do under the antitrust laws. So do you have a sense of whether that is consistent with the approach that the agency has taken in the past, and kind of any thoughts on the examples of conduct that the FTC is referring to there?
Yeah, so we haven't seen a whole lot from the FTC under standalone Section 5 in recent years, so I don't know that there could be consistency, really, with what it's been doing in the past. I think this is a clear statement that the agency intends to look at types of conduct where they think that there's potentially going to be some monopoly or market power in the future. Looking at the examples in the policy statement, I think you just have to think that there's some kind of likelihood element in the analysis. So is, a distribution agreement that requires exclusivity going to someday result in foreclosure, even if the company that has implemented the distribution policy doesn't have market power now and there's a whole bunch of other competitors. I think, and this is probably where the FTC has faced challenges in the past, it's hard to say. There's a lot of speculation involved. So I think it'll be interesting to hear how the FTC comes out on certain types of conduct like that. I mean, are they going to say that exclusivity agreements are per se unlawful under standalone Section 5, maybe? Or are they going to be thinking more about, the market structure, how concentrated a market is, even if there might be plenty of competition now, how likely is it that that's going to go away? Again, I think it's kind of speculative.
Actually, you mentioned earlier that Congress believed the FTC would be the expert body, that they would be better positioned than courts to identify conduct or transactions that would, be unfair to competition. Do you think the FTC has that expertise? Do you think that they've done, you talk about sort of the speculative nature of some of these analyses, but you could envision a world in which you've done the work, you've looked at past examples, and you can say, I know from these 10 past experiences that when shares are this high, or when a major player acquires a smaller player, we see some loss of competition. And this is something that we're an expert about, that we've looked at. Is that something that the FTC is doing, has done? How can they build their case that there should be this standalone Section 5 liability?
Yeah. The FTC has been doing competition law for 100 years now. There's a ton of experience there. What I would hope to see is, some kind of basis in, empirical analysis that says, okay, maybe, Section 7 of the Clayton Act doesn't cover nascent competition in a certain way, but we know, and here's like a study that we've done that shows that competition is very likely to be harmed under certain circumstances, and that's how we'll enforce that. I think the agency does have the expertise to do that, and the people who have been, focusing on doing this kind of work for their entire careers at the agency.
I guess until we see that, and, we'll all be waiting to see what's going to come out of this. I guess I have two kind of wrap-up questions for you, and a little bit speculative about the future, if we want to put it that way. But what do you think we'll see next from the FTC? I mean, do you think we'll see kind of empirical analysis like that? Do you think we'll see just more standalone Section 5 actions? Do you think we'll see some Section 5 claims added on to actions that maybe challenge more traditional conduct, but with, some additional gloss on Section 5 as they're figuring this out? What would your, guess be based on all of your experience?
I could see the agency maybe bringing a merger challenge under Section 7 and saying maybe it's a nascent competition theory of harm, saying that it violates Section 7. And even if it didn't violate Section 7, it also violates Section 5. That seems like a really easy way to start expanding the scope of Section 5. You kind of tack it onto something that is related. I also think there might be some theories of harm that the courts have rejected in recent years that some people think should be within the scope of even the Sherman and Clayton Acts. So things like violation of FRAN commitments in the standard setting context, business arrangements with lock-in effects, refusals to deal by companies that could be viewed as essential facilities. These are all theories of harm that I remember learning about when I was in law school, and then hearing, well, that doesn't fly under the Sherman Act, but maybe it could under Section 5.
And my second question is, what challenges do you think the FTC will face trying to bring more expansive interpretations of Section 5 in its complaints or investigations?
So as Commissioner Wilson's dissent reminds us, the FTC flew too close to the sun in the consumer protection context back in the 80s with its nearly unbounded definition of unfair in that context for unfair and deceptive acts or practices. And the agency ended up being reined in order to preserve its legitimacy. We might see that here. We're already seeing a challenge to the FTC's constitutionality in the Axon case, which is being considered by the Supreme Court. And there's a number of cases that are challenging the legitimacy of or constitutionality of other agencies, other federal agencies. And so I think that it's very likely that if a case were even to go to litigation under Section 5, this idea that the FTC is overstepping its authority will definitely come into play.
Great. Well, Angela, of course, it's still early days, but we're all very, I shouldn't say excited. We are all at the edge of our seat as we anticipate what comes next on Section 5. But before we let you go, we do like to ask all of our guests a couple of questions. The first is to tell us something about yourself that we would not know about you if we only knew you in a professional setting.
Yeah, so you wouldn't know it from looking at me, but I'm half Filipina. And shout out to all the Filipino antitrust lawyers out there. I don't know how many there are. But one of my favorite things to do is to introduce my friends to my favorite Filipino dishes that I used to eat at family parties when I was growing up. And so, if anyone ever comes to my house for a party, or if I ever go anywhere for a potluck, there's, 1 or 2 dishes that I love to make and bring and introduce to my friends. And some people kind of look at the dishes like, oh, what is that? And then usually what happens is one person either knows it or is brave enough to try it. And then it just goes immediately.
And so what is that? What is your favorite Filipino dish?
So my favorite one to make it's called pancit. It's a noodle dish. And the way that I make it is it has 2 different kinds of noodles. It's got chicken, cabbage, carrots, onion, celery, and soy sauce. And it's pretty easy to make, and it's delicious. There's another one, it's called lumpia, which is it's like an egg roll, but it's mostly meat and not very many veggies in it, which obviously is really good.
Well, we're having 2 kinds of noodles, so.
Oh, that sounds delicious. Maybe we'll just segue right into the Curious Hat.
And now it's time for the Curious Hat.
So, Angela, question off the cuff, and actually the one that we thought of for today's episode goes well with your answer, which is to tell us about your favorite holiday and why.
Ooh, good question. I think it would just have to be Christmas. It kind of goes with this, food thing. I used to always go to family parties at Christmas. It was also my grandpa's birthday, and he loved Christmas. And so it was always a really exciting day to get together with family. He would go all out in decorating his house. And I just love thinking about those memories of when I grew up, going over there.
And was there a classic Christmas dish that you enjoyed eating?
Well, it was probably the pancit and the lumpia.
Great. Well, Angela, really appreciate your time today. And for all of our listeners, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.